default, right? So if it was condonation you were seeking, it was a postponement you were seeking, already there you'd have difficulties because there isn't a full explanation, right?
Yes.
Even your instructing attorney is not telling us why these witness statements are only being worked on now when they were due last year in November. However, and this is the difficulty facing the SIU given the order that they seek, because I've had regard to their notice of motion. They seek compliance by a certain date, but what we know now is that he is incapacitated. So if I were to grant that order, from the explanation given, it doesn't appear that he's in a position to comply with the order. So I'm not too worried about your lack of instructions, honestly, because there isn't a full explanation. But my concern mainly is his ability to comply with the order if granted.
Yes.
Okay, let me hear. So the scales are tilted in your favor, Mr. Manala. Let me hear Ms. Monsomoloisane.
As the court pleases.
Are you still with us, ma'am?
Thank you, my lady. I am in attendance. We are indebted to your ladyship for the issues raised with Mr. Manala. Indeed, the affidavit deposed to by Mr. Savela only address events that unfolded in the last few weeks. And the directive was issued, my lady, as far back as the 4th of May, when we had the case management meeting. They failed to comply with that. There was ample opportunity. And we clearly stated, even in the affidavit of Ms. Zondi, our instructing attorney, attached to this application, my lady. That being the case, my lady, this matter has serious and very serious cost implications on the first applicant. This matter has been postponed on several occasions at the instance of the first respondent. And it is only now lately that the second respondent uploaded his affidavit, witness statement on case lines. Otherwise, both respondents have not been cooperating, my lady, or complying with the directives issued by the special tribunal. And our instructions are to see.
Me deal with my difficulty, because what we know about Mr. HLATSHWAYO is that he's not in a position to give any instruction. So is he in a position to comply with the order if I grant it? I doubt it. Not from what we've been told. And that's my difficulty with granting the order today.
My lady, our submissions are that, in fact, our instructions are to ask this special tribunal to take into cognizance the fact that the first applicant is incurring costs.
Yes.
But regarding the postponement sought, our hands are tied. And
well, they're not seeking a postponement. They're not seeking. They're simply saying just if you grant an order, it may not be complied with because he can't give instructions.
But my lady, they are acting for the first respondent. They need to know Mr. Manala should make a specific application or request to your ladyship.
But where are those instructions coming from? He's explained he doesn't have instructions. So the best his attorney could do is explain why he's not getting instructions, and that's what he's done.
My lady, perhaps I need to explain this to your ladyship. Up until the last few days, Mr. Savela is saying he became aware of the outcome of the arbitration proceedings in sometime during July. But now we need to focus on what happened before July. I'm quite aware of what your ladyship is asking me, which is a difficult question regarding what.
It really is irrelevant what has happened for the purpose of the present discussion. Maybe sometime in the future, we can really problematize the fact that we don't have a full explanation. But let's focus on the first respondent's capacity to comply with the court order. That's really where my difficulty is.
With due respect, my lady, there is nothing that, your ladyship can do, regarding the order that we are seeking. This court cannot grant this order that we are seeking now.
Yes, so I think the application should simply be removed from the roll. If it becomes necessary, you can reinstate the application. And at this point, I think costs should also be reserved.
I was about to ask for that, my lady.
And then what do we do with the trial next week?
Obviously, my lady, as Mr. Manala has already indicated, this court will not be in a position to proceed to the trial. We do not have the witness statement of the...
we could proceed, but he's not in a position to give instructions because he's incapacitated.
Thank you, my lady. Yes. But that will amount to a procedural irregularity of some sort, in that which will be reviewable.
No, judges are not reviewable. They appeal
but my lady, it will be an irregularity and a serious irregularity.
So you seem to be suggesting that or accepting that the trial also can proceed.
Obviously, the trial cannot be proceeded with, my lady.
Okay. Mr. Rasakhala?
Based on I just want to finalize this. Based on that irregularity, my lady, which will be committed by proceeding in the absence of a party who is not in a position to can attend due to his health. We've got confirmation from the medical reports that he is physically indisposable. That being the case, my lady, the trial that is set down for the 22nd to the 26th cannot be proceeded with.
Mr. Rasakhala?
As the court pleases, my lady, I'm in agreement, my lady. Also, I must bring it to your attention that there is a statement that was a supplementary statement that was filed only yesterday. And I have perused what the content and the annexures. There are serious implications. They're raising serious issues, which I think we should also consult with client and also the first
Who filed the supplementary statement?
The SIU, Rexon Musinga, the SIU investigator.
Oh, I see.
Attached to it is FICA, Financial Intelligence Center report, and bank statements and so on and so forth. We will have to consult. There might be a need for us to also supplement our witness statements. Yes. So
it appears that the trial would not be ready to proceed next week in any event.
Correct. Okay. Thank you, my lady.
I don't need to hear you, Mr. Manala, do I?
Not really, my lady, but out of caution, I feel compelled to make one brief submission.
Yes.
Yes. Just out of caution, my lady, I'm aware of the background fact that Mr. HLATSHWAYO has been dismissed from work, and he was just now reinstated by way of arbitration proceedings that were concluded with the employer. And I'm also acutely aware that when you reserve the issue of costs, as you do now, and the potential postponement of the trial next week, it may well be that in future it comes back to him to say he takes responsibility, the financial responsibility for the wasted costs of the postponed trial. And I just wish to drop it to the SIU to say, they may consider the prospect of proceeding by way of a separation so that the costs are not entirely wasted. So it shouldn't necessarily be that because he's ill and unavailable, they can proceed with the trial on the available slot as against the other party that is available. So it shouldn't really be entirely up to him, because when you look at the relief claim, there's a separation of issues against him and issues against Black Dot as the other defendant. So just in passing, I'm mentioning that point as the court pleases. Those would be the brief submissions, my lady.
Thank you.
As the court pleases, my lady, I'm not quite sure if I need to reply perhaps to what Mr. Manala has.
I think it can just be noted. It can just be noted. Yeah. Okay, the application to compel is removed from the roll. Costs are reserved. The trial scheduled to start next week, Monday, is also removed from the roll and costs are reserved. Ms. Moloisane, please prepare a draft order to this effect.
As the court pleases, my lady.
And email it in Word. Yes, in Word format, please.
Okay, we will do that, my lady.
It's shared with the other side so that if they are not happy with the content, then they can make input. But I do require the court order today. So
as the court pleases, my lady,
should make time to settle that order.
As the court pleases, my lady.
Thank you, the proceeding sergeant.
Thank you.
As the court pleases.